Good afternoon to all our participants. Our webinar today is on the title, Understanding the Nuts and Bolts of Chapter 11 of the US Federal Bankruptcy Code and the Uncitral Model Law on Cross-Border Insolvency, Lessons for Reforming Sri Lanka's Corporate Restructuring Laws. I'm Anuruddha Pereira, the co-chairman of the Overseas Relations Committee, and on behalf of the committee members and the Bar Association of Sri Lanka, I warmly welcome all of you who are attending. I'm extremely sorry that we had a slight delay in commencing proceedings today. We had a slight technical glitch, but everything's good now and we are good to go. The webinar focuses on a very important and topical subject. Sri Lanka is just learning to manage the shocking impact of an economic meltdown just when the country started to breathe from the devastation caused by the COVID pandemic. These events have dealt a catastrophic blow to the country's private sector, which now needs to find innovative answers on how to deal with the challenges where many matters dealing with insolvency and corporate restructuring will be at the forefront of their focus. The legal framework that supports this process will be most important in dealing with these challenges, hence the topic today. Our principal speaker today is Mr. Ronald Silverman, partner at the New York office of Hogan Lovells US LLP, and the co-head of business restructuring and insolvency practice of Hogan Lovells. Mr. Silverman has extensive international experience in the areas of corporate restructuring and insolvency, and is a highly sought after international professional in these matters. Next, we have Mr. Debanshu Mukherjee, co-founder and lead at Vidhi Center for Legal Policy, New Delhi, who will give an insight on how the Indian framework evolved on the topic in discussion. Then we have Mr. Peter Briggs, Managing Director at Alvarez and Marshall Holdings LLC, New York, another highly sought after, globally acclaimed professional who has extensive experience in insolvency and corporate restructuring work, having worked in over 30 countries dealing with similar matters. We are also very happy to have the participation of Mr. Nicholas Moller, Principal Counsel at the Asian Development Bank in Philippines, or from Philippines, who has been involved in dealing with countries that have dealt with similar situations, and he can give us an insight to his from his long-standing experience in these matters. And we have Mr. Chanaka De Silva, President's Counsel, partner at Nithya Partners, a leading law firm in Sri Lanka, and a senior legal practitioner heavily involved in advising many corporate institutions and certain state institutions dealing directly with the topic today. Mr. De Silva is a member of, formerly a member of the Attorney General's Department, the principal institution which advises the state, and if I may so, my commercial law lecturer at Sri Lanka Law College. The session today will be moderated by my dear friend and batchmate and the former, one of the former Deputy Solicitor Generals at the Attorney General's Department, Mrs. Shahida Bari, who has long-standing experience in advising state institutions such as Central Bank and the Ministry of Finance of Sri Lanka, and Mr. Shehan Soiza, State Counsel, who is a dynamic legal practitioner from the Attorney General's Department, functioning as an advisor to the state. I dearly miss the presence of our most supportive chairman, Dr. Asanga Gunawansa, who is overseas with a state delegation at present. And once the proceedings start, Mr. Manjuka Fernando Pulle, our dynamic convener, who has made an enormous contribution to organize this webinar, will support our moderators and deliver the vote of thanks. At the end of my welcome address, the president of the Bar Association will speak a few words, and thereafter the moderators will take over. The moderators will give the proceedings, give the agenda for the proceedings. They will not introduce the speakers again, and we will straight away go into the proceedings thereafter. I now invite Mr. Salia Piris, President's Counsel, the President of the Bar Association of Sri Lanka, to speak to the participants. Thank you and welcome again.
Thank you, Anuruddha, and thank you, everyone. We welcome the participants, and I wish to thank the panel for coming on board on this webinar. And we do hope that the lessons which you will share, that Sri Lanka will be able to learn from the lessons and to understand what is being spoken of today, especially about the bankruptcy code and cross-border insolvency, and how Sri Lanka can learn from that. So thank you once again to the Overseas Relations Committee, the participants, and the resource personnel for taking time to come on board at our request. Thank you.
Okay, thank you, dear sir. It's my absolute privilege to be a moderator of this session, which has been organized by the Bar Association of Sri Lanka. And as you know, the topic of the webinar is understanding the nuts and bolts of Chapter 11 of the US Federal Bankruptcy Code, the Uncitral model law on cross-border involvement. Now, from my practice, or the limited practice that I have understood one thing, and that has been summarized in a judgment of the Court of Appeal in Colombo Engineering Enterprises versus Hatton National Bank, 1999, 1 SLR 72. Now, this is what the court said. While expeditious procedure was no doubt intended by the legislature, the court must always be conscious that the winding up of a company may have far-reaching consequences, not only affecting the company, but also with it. Now, in a nutshell, my experience has been that bankruptcy or a winding up in Sri Lankan terms should be the last resort. Because in every company, there are so many employees there. And when that company goes into bankruptcy or winding up, all of those people are affected. As a state counsel, I regularly appear in the commercial high courts, and especially in cases where there are apparel companies, where government are involved. I have seen so many individuals affected. On behalf of the state, we try to give them some relief by appealing for what we call statutory creditors, who are also preferred or preferential creditors in terms of the law, such as the Commission of Labor. In one particular company of this nature, there were 7,000 employees who were affected, who did not have their statutory benefits. And the litigation is going on for the last 12 to 13 years. And every day I go out and I try to compete with statutory creditors, not on behalf of the state, but for those employees, those people who work in the government, who gave their lives maybe 10, 15, 20 years to the company. And at the end, they do not even have their statutory rights. So I have seen the repercussions of such matters. And from my experience, I've seen the suffering that people will suffer if the company goes into bankruptcy. So that is why I believe the BSL, and especially I must mention Manjuka Fernando, who understands that company is the blood of our economy. It employs people and it keeps the country moving forward. In that context, I believe all the experts who are esteemed foreign and legal practitioners who are absolute masters in this subject today. So I will take you through today's agenda so that all of you can understand how this webinar is structured. First and foremost, Mr. Peter Briggs will be giving, first and foremost, Mr. Ronald Silverman will be given an introduction to the topic, and he will give a presentation, a very comprehensive presentation, which I'm sure will be available through email to you at some later time. And also you can see it while he makes a presentation for 20 to 30 minutes. Thereafter, with regard to the practical approach, Mr. Peter Briggs, I'm really looking forward because I really want to see a person who has practical experience from a practitioner's perspective, giving us the way forward. He will be speaking for 15 minutes. Thereafter, right across the stage, Mr. Dibanshu Mukherjee will give us the perspective on Indian perspective and how they got there. And with regard to the Asian context, Mr. Nicholas Muller will be speaking on ADB's role in corporate restructuring. And finally, but definitely, saving the best for last, Mr. Chanaka De Silva, President's Counsel, will be going through Sri Lanka's perspective and what Sri Lanka is to expect. All of the speakers will be speaking for 15 minutes. Thereafter, my co-moderator, Ms. Shaida Bari, will go through a question and answer session. She will moderate the question and answer session for 15 minutes, where I have already seen some questions being posed. So I believe this will be a really interesting session in every context. And therefore, without keeping the speakers or you waiting forward, may I now call upon Mr. Silverman to give an introduction of the topic.
Thank you very much. Can people hear me well?
Yes, we can hear.
They can hear me.
Wonderful. We always like to rely on the magic of Zoom, but sometimes the magic is better than others. Thank you very much. That is an incredible introduction of the topic and incredibly appropriate. I wanted to thank the Bar Association of Sri Lanka and my esteemed co-panelists for the opportunity to present today with them on subjects that are changing economies and changing people's lives. So they are incredibly important, and we hope that we can provide some useful perspective. The topic today is twofold. First, to discuss the system of corporate reorganization in the United States called Chapter 11, and also speak a bit towards the end of the presentation about the United States version, which we call Chapter 15, the version that the US has adopted of the Uncitral model law on cross-border insolvency. That's a more streamlined restructuring provision that's designed to give assistance to restructuring and bankruptcy proceedings that are outside the United States, but to provide assistance by United States courts to those proceedings. But if we begin with the main type of corporate restructuring in the United States, Chapter 11, I think it's the best way to introduce it is to introduce the philosophy, because that permeates all the tools that are contained in our law to give effect to a certain philosophy of restructuring. And that philosophy is twofold. First, the goal of Chapter 11 is to maximize the value and continue the corporate enterprise of the endeavor. So it's to maximize the value in the restructuring. The goal is not winding up, and it is not liquidation. And in fact, when the United States Bankruptcy Code was enacted in 1978, some time ago now, that was a sufficiently radical idea in terms of corporate restructuring laws around the world. Many jurisdictions did and still do focus on winding up and liquidation, stop the business, divide the assets, pay back the creditors. But the theory behind Chapter 11 is that the going concern business is worth more to the creditors and a better solution for the employees and a better solution for the equity holders than is winding up in liquidation. The other philosophy, main point behind Chapter 11, and it's consistent with the view of maximizing value, is that a trustee is not immediately appointed in our system. The existing management, once they enter Chapter 11, remains in place. And it has been said by some critics of this view that that's like leaving the fox in charge of the hen house. But the Chapter 11 view is that businesses can encounter financial difficulty not through their own fault, not through fraud, but through external circumstances, changes in the economy and changes in the business. And therefore they are the quote honest but unfortunate debtor that needs to be restructured rather than thrown out. So we have a system where the management stays in place because the theory is that they know the business better. When a trustee comes in to displace management, they're better suited for freezing a business, breaking up assets and selling than continuing on the business. So with those two sort of guiding principles in mind, let's talk about how Chapter 11 it works. As I said, it is a restructuring proceeding, and it has tools to restructure both the financial and the operational aspects of the business. That is not just the debt, but even the ongoing contracts and business operations of the enterprise can be changed and restructured through the law. The Chapter 11 company has significant responsibilities when it's in Chapter 11. Once a Chapter 11 case has been commenced, the company cannot generally pay its pre-bankruptcy, we call them pre-petition, because the Chapter 11 is commenced by filing a petition. It cannot pay its pre-petition obligations without court approval as a general matter. This reflects another philosophy behind Chapter 11, which is all similarly situated creditors should be treated equally. So with respect to old debts, pre-bankruptcy debts, until you get to the resolution of the Chapter 11, which comes in the form of a plan of reorganization, which will describe how creditors and stakeholders are treated, old pre-bankruptcy debts are held frozen so that not one creditor doesn't gain an advantage on another. Chapter 11 also has heightened disclosure requirements. There's a tremendous amount of transparency in Chapter 11. The court system is generally open in terms of access in modern day with electronic facilities. All the pleadings, all the filings are available to the public. Public can generally attend court freely. They can do that in person. Now they can do that on Zoom or phone and listen in. So there's a huge amount of transparency, and that also means that there has to be a huge amount of information provided. And there's extensive requirements for Chapter 11 debtors to file information about their assets, their liabilities, their business operations, so that the creditors can understand what the facts are and therefore how to reorganize. One other significant aspect of Chapter 11 to keep creditors being treated equally is that during Chapter 11, the ordinary course business of a company continues to run without court involvement. It can continue to sell inventory, it can continue to purchase raw materials. But what we call out of the ordinary course transactions, things like financing, things like entering into non-ordinary course contracts, selling assets, those require court approval. So things that change the balance, if you will, and the status quo, those cannot happen in Chapter 11 without specific court approval. So that also means, again, with the transparency, there is the company, the debtor, needs to apply to the court for permission to undertake these transactions, and every creditor and every stakeholder has the opportunity to be heard and object if they will. So these are approved by the court. The upshot of all of this is that there's a lot of transparency, but there's a lot of requirements, and therefore there's also a lot of expense. So that's something to keep in mind. Chapter 11 may be well suited for larger enterprises, and in more recent years, we've introduced in the US a smaller, more streamlined regime of Chapter 11 for very small debtors to address that. Let's talk about some of the significant policies and tools of Chapter 11. One of the first and foremost that people have heard about is what we call our automatic stay. As soon as a Chapter 11 petition is filed, without any affirmative order from the court, by statute, a moratorium on creditor actions comes into place. That applies to actions to seek to recover debts, actions to enforce liens, actions to exercise control over the assets of the debtor. That there's an automatic moratorium that's put in place that prevents all of those, and that even applies to secured creditors in our system. There are exceptions for secured creditors to get relief from that stay if their collateral interest is being prejudiced and declining in value. But in general, there's an automatic stop of all creditor actions that's designed to give the Chapter 11 debtor a breathing spell so they can reorganize without their assets and business being dismantled. And if creditors do violate that automatic stay, they can be subject to penalties and sanctions. The Chapter 11 also has other tools to facilitate the company reorganizing itself, all with an end game towards getting to a plan of reorganization. But even during the case, there are tools to let the company improve itself. One of those is that with respect to ongoing contracts of the company, we call them executory contracts, and this applies to leases as well. They can either be continued by the company or they can be rejected, meaning the company doesn't have to perform anymore. That cannot happen outside of Chapter 11. It doesn't mean that the creditor has no recourse. If a contract is rejected, then the creditor will have a damages claim, like any other unsecured creditor. They may not be paid in full. They may be paid whatever distribution on their unsecured claim is allotted to all unsecured creditors. But what that does is that frees the company, allows the company to free itself up from an uneconomic and unproductive contract so that it can focus on its productive business. It can also, as I said, affirm and continue contracts, and it can even assign them. And under U.S. bankruptcy policy, to permit free assignability and for the company to monetize its valuable contracts, it can even assign them over existing defaults if the monetary defaults are cured. Another significant component that I know Mr. Briggs has extensive experience on in Chapter 11 is financing. Right? If a company doesn't have any money to continue, how does it survive until it gets to a reorganization plan? Chapter 11 may be the most advanced system of jurisdictions around the world for providing new money to a Chapter 11 debtor. The Chapter 11 system provides, with court approval, that new money can be borrowed and it can be senior to unsecured creditors as a super priority basis. And the system also provides that new money can also be secured, and in some cases, even secured above existing secured financing, which is a fairly controversial subject in most of the world. The requirements for that is that any secured creditor who is going to have its lien, what we call primed, meaning there'll be a new senior debt above it, there has to be a showing that their existing security interest is protected. Perhaps, for example, there's more value in their collateral than the amount of their debt. So even with the debt on top of them, they still have value in their collateral. Secured creditors never like that because we don't know at the end of the day if that proves right, but a court makes a decision on that. And the view is that's necessary sometimes in order to provide financing and induce financing so that this company can continue. One other significant tool, I think, before we get to the subject of a plan of reorganization, which is how we resolve a Chapter 11, are asset sales. Just like disclaiming or continuing contracts, the bankruptcy code under Chapter 11, under a certain section called 363, and I only mention that because it's one of the prime sections that people will mention as a term of art. The bankruptcy code allows companies in bankruptcy to sell assets. And what's remarkable about this is they can sell assets free and clear of existing liens. The lien holders are not left without remedy. The liens will attach to proceeds of the assets. And the lien holders also have the ability to credit their liens in that asset sale if they think the assets are being sold at too low of a value. But in order, again, for the company to maximize the value and focus on the business that it wants to continue, it may want to sell ancillary assets or non-core assets, and the bankruptcy code permits it to do that. Again, free of existing liens and claims, and a court that'll be done on motion, approval by a court, and the court will bless that the sale was done in good faith, that there was adequate marketing, it was a fair price. And therefore, that's actually very attractive to buyers because buyers get very clean title to those assets and they don't have bankruptcy or clawback risk on them. So it's advantageous for the seller, the debtor, and also for buyers. I would mention also that, like many other jurisdictions, Chapter 11 has rules for avoiding preferential or fraudulent transfers, so that all creditors are treated equally. Some of our Chapter 11 rules are a little more considered a little more draconian by some systems than others. Certain transactions done shortly before a Chapter 11 filing can be clawed back, even if there is no fraudulent transfer behind them. The theory is if they're done shortly before the filing, we want to make sure that all creditors are similarly situated and that there was not a race to the courthouse. And some creditors were able to attain recoveries, shortly before the filing when others weren't. But to suffice it to say that we do have rules that provide for clawback of preferential transfers that happen or constructively fraudulent transfers that happen before the short period of time before the filing. So now we get to the end game, the plan of reorganization. Now that a company's gotten into Chapter 11, it's been able to obtain financing, it's gotten rid of its non-core businesses, some onerous contracts, it's left with its valuable business, the one it wants to focus on. How does it get out of Chapter 11? It does it with a plan of reorganization. That's the goal of every Chapter 11 case. In order to promote the company's efforts in that, our law gives the debtor the exclusive right to propose a plan of reorganization during the first 120 days after a filing of bankruptcy. That exclusive period can be extended up to 18 months. The point of that is it does hold creditors at bay from imposing their views on what they would like to see in a plan, and it does give the debtor a preferential right to propose that plan. Creditors do have the ability to petition the court to file their own plan, but that's not as common in the early days of a Chapter 11 case. Again, with the theme of transparency, the Chapter 11 plan, when that's presented to creditors, it has to be accompanied by a disclosure statement that's similar to a bond prospectus or an offering memorandum, so that creditors can understand what is being proposed to them. That has to provide adequate information for an investor to make a decision, describe the assets, describe the liabilities, describe what creditors are going to receive what consideration and in what order in the plan, so that they can not only vote on that plan, but also have the opportunity to object to it to the court if certain statutory requirements for approval are not met. A plan must do certain things, and a plan may do certain things. The plan must describe classes of creditors. It must describe which classes are unaffected, which classes are affected and we call impaired. It must describe the way that those classes will be treated. It must provide for equality of treatment between creditors in each class. Can't prefer some creditors versus others that are similarly situated. But what the plan may do is very flexible. It may assume or reject contracts that haven't been treated previously. It may settle claims, again, with court permission. It may sell further assets of the company. It may modify rights of creditors subject to standards. It may even modify rights and claims of secured creditors, provided that they're ultimately given the economic value of their secured claims, but they can be given that value on terms that are different than the existing loan. For example, that loan may be stretched out. It may be paid over a longer period of time, provided they end up with the net present value of their claim. But that provides flexibility to reorganize finances. There are standards, as I mentioned, for Chapter 11 plans to be approved. The highlights of those standards are that each class of claims that is impaired must either accept the plan, with one exception that I'll get to, that is famously called our cram down rules. But the class of claims must accept. There must, in all events, be at least one class of claims that is impaired that accepts, even if others don't. That's sort of a minimum litmus test that someone has accepted this plan. Some classes accepted it. The plan has to be determined to be feasible by a court. It must work. It can't likely end up in a failure, 1 year down the road. It has to be economically and operationally viable, or the court in the court's judgment, or it won't approve it. And also, significantly, as a significant protection to individual creditors, a creditor may not get less under this plan than they would in a winding up in a liquidation. That's a bare minimum test. I mentioned the plan must be approved by classes of creditors. That's done by voting. Our voting standard is, in each class, 2/3 in amount and more than 50% in number of claims that actually vote must approve. That's a more liberal standard than in some jurisdictions like the UK, where there's a 75% threshold. And as I mentioned as well, that if some classes do not accept the plan, it can still be approved over their rejection if certain minimum requirements, or important but minimum requirements, are met. Those two types of requirements are, first, what we call the absolute priority rule. For unsecured creditors, no junior class of creditors can receive anything under the plan if the senior class hasn't been paid in full. It's a waterfall that the Chapter 11 regime utilizes. And to speak to one of the important points that one of our prior speakers noted, there's protections for employees. Certain claims are entitled to priority. So even though the goal is that the company should continue and employees will continue in their jobs and be paid in full, in all circumstances, there are priority claims for certain things, like certain types of taxes, employee wages, pensions, up to certain amounts, so that even in a worst case, the employees are paid. And even on their pre-bankruptcy claims, if there are some that haven't been paid because there was a lag in payment between payroll and when the case was filed, they're entitled to a priority above regular unsecured creditors. And in practice, what that means is courts on the first day of Chapter 11 cases approve those payments of unpaid wages to employees straight away. We don't make them wait to the end of the case, because they're going to get that priority paid anyway. The other protection, what we call for cram down, even if a class of claims does not accept the plan, when this applies to secured creditors is that can still be approved over the secured creditor class descent, and there's typically a class for each secured creditor. But their treatment can be approved so long as they receive cash payments or something similar that equal over time the present value of their secured claim. So again, you get your value of your secured claim paid, but it may be over time on a deferred but equal value basis. And at the end of the Chapter 11 plan, it can provide for financing. The plan will also commonly provide for exit financing, whether that's new debt or whether that's the creditors. Some of the creditors or financiers and lenders agree to convert some of their existing debt to equity capital. So they get their value, but in form of equity capital, which may be easier for the company to maintain. But at the end of that, if the court approves the treatment of the various creditors and the feasibility of the plan will be confirmed, the old debts and claims will be canceled, the company will leave Chapter 11 and continue on as a going concern. So that's a little bit of an overview of Chapter 11. Let me just take a few minutes to describe Chapter 15 for the audience so that I'm mindful of the time for all our panelists. As I said, Chapter 15 is a streamlined provision of the United States Bankruptcy Code, and it adopts in large fashion almost all of the Uncitral model law and cross-border insolvency. And the goal is to provide for a fair and efficient administration of restructuring proceedings or bankruptcy proceedings in multiple jurisdictions, and to coordinate them so that the primary proceeding can be effectuated, and when it requires or its administrators require assistance from another country like the United States courts have a statute to provide them assistance to enable the restructuring in the foreign jurisdiction. One of the things that the Chapter 11 law does, it provides for very flexible relief that can be granted to a foreign restructuring proceeding. And sometimes that relief is granted on an automatic basis, sometimes it's granted on a discretionary basis. And the major distinction there is that when a foreign restructuring or bankruptcy proceeding is considered a foreign main proceeding, that's determined by if its center of main interests, its focus of its business and presence is contained in the foreign proceeding, then under Chapter 15 in the model law, we consider that proceeding to get some automatic deference. And the US law will say that automatically there will be a stay. Once Chapter 15 case is open, there'll be an automatic stay of actions in the United States against the debtor and its assets in the United States. Asset sales in the United States of assets in the United States will obtain protections under United States law. Certain post-filing transactions will be prohibited so that we preserve the status quo, and that relief will be granted automatically. If a company is not a foreign main proceeding, it can still be granted protections under Chapter 15 on a discretionary basis. And the discretionary relief is very broad. We can provide a foreign proceeding with discovery in the United States, staying actions, freezing actions, even providing that assets in the United States should be transferred to the foreign proceeding and entrusted to the foreign administrator for distribution to creditors in accordance with local law. The flexibility is very broad. And the end result of a Chapter 15 case is typically to provide an order that gives effect in the United States, full faith and effect to the restructuring orders that take place in the primary proceeding. And that's typically other than a stay and some discovery needs that might be needed, that's typically the main reason for providing a Chapter 15. For example, if your company has United States law governed bonds and your proceeding in your country effectuates a restructuring of those bonds, you want to make sure that rogue creditors in the United States won't seek to try and attack the company later on in the United States. the Chapter 15 court can order that the foreign restructuring that has restructured those bonds and those liabilities should be given effect in the United States, and therefore the company has comfort that they won't be attacked down the road because the United States court has given assistance and cooperation to the foreign proceedings. So with that, I think that's a short but a high-level overview of Chapter 15. And now I thank everyone for their time and open the floor to the next stages of our moderators.
Thank you very much. That was really insightful. And most of all, something that I'll take away is the fact that you mentioned that Chapter 11 provides for new money to be brought in and given. And it's a secured over secured creditor, it seems, that process. And also that court approves the salaries and wages at the inception. So that would have put a lot of relief for the people who were really affected. In that context, a lot of insights were given to the crowd and to the panelists, and I'm really happy to have heard all of that. Thank you so much. So may I now call upon Mr. Peter Briggs, the practitioner, to give us the practical aspects. I'm looking forward to hearing some novel ideas as well.
Thank you very much, and thank you, Ron. Ron, I just point out, I saw that Ron had sent around a PowerPoint slide deck summary of Chapter 11 and Chapter 15, and I'm sure that's going to be shared with your audience. It's an excellent referral document, good summary, and I read through it last night to see if there's something I'd missed. It was the same Chapter 11 I've always known, but it's an excellent reference document. And so I encourage everybody to take a look at it. It's a lot of dense information you've just had. And I found it very helpful myself in preparing for this call. I'm going to start with what I'd like to cover in available time. And I understand I have 15 minutes. I hope I still have 15 minutes. Is some context in which we apply bankruptcy and insolvency laws. And that should color to some extent how Sri Lanka views how to reform its laws, making sure they're fit for purpose. Secondly, I want to talk a bit about the role of a chief restructuring officer and the roles of management in a bankruptcy proceeding, an insolvency proceeding. And then I do want to specifically address, and Sehan Zoya just mentioned, a couple of the highlights out of Chapter 11, and I want to make sure I give you why I believe what the benefits are of Chapter 11 versus alternative legal systems that you might use as a basis for reforming Sri Lanka's laws. But just getting started, two apologies I want to make about my qualifications as a speaker here today. First, I'm not a morning person, and I'm here under duress. Manjuka did not tell me this was going to happen at 6 a.m. in the morning. And like many lawyers I know, they don't really get rolling until about mid-morning, and that's true for me too. So you'll have to bear with me if I'm not at my most articulate. I'm drinking coffee, as you probably noticed, as fast as I can. Secondly, I'm not a lawyer. However, and I realize I've got I'd say a Zoom room full of lawyers. But it was 42 years ago this month that I worked on my first Chapter 11 bankruptcy case. I've worked on, I don't know how many dozens of them at this point. And I have worked on insolvencies in, I don't know exactly how many countries, but a lot, in the dozens, including on the ground as either an officer or director of companies, and more than 30. I say more than 30 because I stopped counting at some point. It's a bigger number than that, but I could rattle off the 30 that left a bruise from the process. The largest of which being Lehman Brothers. I was part of the management team of Lehman through its Chapter 11. I think we were in 85 jurisdictions. I was not involved in all of them. But in that case, I had responsibility for the wind down of the loan and fixed income, the bond portfolio, the derivatives portfolio, the loan portfolio of Lehman. And therefore, we had counterparties we dealt with pretty much everywhere on earth. It was a great opportunity to compare and contrast different insolvency systems around the world, the likes of which we haven't seen. I'm a partner in a firm called Alvarez & Marsal, which many of you may not have heard of. We are not a law firm, nor are we an accounting firm. Our firm was born, and Ron referenced the change in the bankruptcy laws in 1978. The next economic downturn in the United States, which was quite a severe one of 1980 to 82, gave rise to the idea that as companies went through bankruptcy, it's a process that most management teams or boards would never have had experience with before. And so there was room for a professional other than a lawyer to advise that board or management team, often at their request, but also at the request of creditors as a condition of securing some benefits from creditors, relief to the debtors, that they take on board someone who could help them manage the process, including preparation of the financial information and information needed to the court, advise creditors, and be something of an honest broker between the debtor and the creditor as to the true condition of a company. Management's often being very defensive about how they found themselves into bankruptcy court in the first place. This came to be known as a chief restructuring officer. Our founding partners of our firm were some of the first folks to use that concept and sell it. We have now, and when I started with our firm, we had a single office in New York. We now have close to 8,000 of us in 75 offices-ish in 30-something countries, basically promoting the idea of corporate rehabilitation as opposed to liquidation. And this is a concept that really is an extension of and its bias as certain that creditor claims are paid in order of seniority and efficiently. The value is passed through because creditors have a right to get their money back. The debtor system, the system in the United States is principally about giving that business a chance at a rehabilitation. Whether that's with the original management team or not, you're trying to preserve value, you're trying to preserve jobs. And with that, I'll talk about Sri Lanka for just a minute. I've recently been in Sri Lanka and we'll be back there next month, meeting with senior government officials, some of the leaders of your both state-owned and private banks, leaders of some of your large state-owned enterprises, your state-owned enterprise restructuring committee. These are the kinds of folks we are talking to about how we can be helpful to this process. Today, I run our sovereign advisory business, but that's not the topic of conversation today. I spent about half my career as a creditor, largely with Citibank, and I started the restructuring finance business, providing debtor in possession financing and reorganization financing at Citi back in the early 90s. And I've spent about 20 years with Alvarez & Marsal, principally doing debtor advice and serving as either a interim CEO or chairman or chief restructuring officer of companies going through bankruptcy. So that's, while I'm not a lawyer, I get to spend a heck of a lot of time hanging out with lawyers in all kinds of bankruptcy courts and insolvency proceedings. What do we do in this process? And I just last comment on Sri Lanka's situation with the breadth of financial distress in your corporate community is you want to have a legal system that is going, well, in individual cases, getting the priority right matters of claims. When you're looking on a broad economic basis, you want to give as many businesses as possible the chance to be rehabilitated, to grow, to be active economic actors and employers. this is the only way you're going to grow your way to a better standard of living for your population and to service the debt in the negotiations that are going on right now. So this is a very important component of the turnaround of Sri Lanka, is how you address the corporate insolvency process. The role of a CRO, just for a minute, and of management generally in a bankruptcy. Most businesses find themselves there. It's not something one does by choice very often. It's because you've run out of options. 9 times out of 10, it's because you've run out of money, as opposed to leverage. Occasionally, companies file because of litigation against them, big claims, or because there's been material fraud. FTX, crypto business comes to mind recently as something that's folded. And we've just watched Silicon Valley Bank's holding company file bankruptcy. One of my partners is the chief restructuring officer in Silicon Valley Bank. We're also the advisors to FTX. These situations happen, but they're unusual. More often, it's a business that has not made money for a period of time, probably borrowed money to fill in its hole, run out of ideas, and run out of patience of their creditors continue in the modus operandi they were in. So by the time you file, you have no money. You've probably wound down, you've collected all your receivables, you've wound down your inventory as much as you can, you've stretched your payables, and now here you are in bankruptcy, and with very little credibility with your creditors. How do you start that death spiral? How do you start to unwind it? One of the first step, and I'll now make reference to the law, the automatic stay stops the pressure, at least for a period of time. At least as importantly, and arguably most importantly, access to fresh money. It is extremely difficult to turn around a business if you can't rebalance, be able to purchase new inputs if you're a manufacturer, or pay your employees if you're a service business. And so there has to be some injection of fresh money. That's what the debtor in possession financing allows one to do. This is super senior financing above the claims of the existing creditors. Why would existing creditors, pre-petition creditors, allow a company to not only borrow more money, but do it senior to them? Because it allows the enterprise to protect its value, that the company is worth more alive than dead. The alternative is liquidation, where you're typically going to get a very low value for the assets and no value for the enterprise as an ongoing business. Then you're much better off to allow the business to borrow a little more money and keep its operations afloat, at least long enough to determine if there is a plan of reorganization. So when I come in as a CRO or interim CEO, I've got a few basic things that the creditors, the court, the owners expect me to do. Answer a few questions. Should this company be fixed, sold, potentially quickly, or liquidated? Because it does not have an ongoing value. It is not a viable business. It is not attractive to a potential buyer. And so you shouldn't waste time. You should just about go, rather than bleeding more money out, you should wind up its activities and pass whatever value is recoverable through. And that is where most of the, I'm generalizing. I lived in Germany and I started our business for A&M in Germany and Central Eastern Europe. I lived in the UK. I ran our UK restructuring practice. So, and I've worked extensively across the continent under the French system, very difficult Belgian system. So I'm making generalizations, but it's born out of some personal experience in a variety of these major legal systems. They fundamentally exist to give creditors back what value is there. The UK system is very efficient for helping companies get sold or to resolve its issues, particularly through prepackaged insolvencies with its creditors. But none of the continental European systems are as efficient at supporting rehabilitation. Biggest differentiator, ease with which one gets new capital into the business, preservation of the management team on the assumption that, as Ron said, they are an honest management team, and that they are doing the right things by the enterprise, not by their own personal interest or those of shareholders, particularly the case when the ownership and the management are the same. Though you always worry about that. In bigger companies, you tend to have a distinction between who the shareholders are and who the management are. In smaller and mid-sized companies, more typical in Sri Lanka, owner and management are often the same thing, and you'll have more cases where that can be challenged as to whether people are looking at for the best interest of the business or their own wallets. And that is where there is a greater need for having an objective, more independent voice in the management of the assets in the estate while operating in bankruptcy. I always talk about 3 L's of bankruptcy: leverage, which needs to be reduced, but usually isn't the ultimate cause of bankruptcy; liquidity, which typically is, and leadership. And the last of those is as important as the first 2, but much less spoken about. Do you have an answer to the question, should this company be fixed, sold, or liquidated? And do you have the credibility to bring a business through a plan of reorganization process and back out? Can you win over the trust of the creditors or providers of fresh money, or a potential buyer, that business is, you are being good stewards of that business? And so a lot of focus, and this really isn't a legal process unless there's outright fraud. It is a judgment, a business judgment on the objectives and competence of that management team, regardless of whether a business is in bankruptcy or not. All restructuring processes happen against the backdrop of restructuring. For every company that goes in, I don't know what the percentage is, maybe Ron would know, but I would guess that there's 3 companies that go through some process of negotiation with their creditors outside of bankruptcy. But they're doing so against the threat, whether it's being threatened against them or by their creditors, or the debtor is threatening the creditors that we will file if you don't give us some relief. What's important in either case is there be clarity. Whether you choose to use whether Sri Lanka now chooses to use a Chapter 11 styled bankruptcy for its own local reforms, or another excellent system, the English law system, which and UK insolvency. By the way, we're UK insolvency administrators ourselves as one of our service lines in our firm. Both systems have their benefits, but what's most important is clarity. Clarity of understanding of what will occur, what the roles of the players are, and really importantly, the roles of the judges. And here, I'm not a lawyer, but I have learned, I worked in Eastern Europe. I lived in Prague in the 90s and was involved for Citibank, was involved through that period of time of transition. And there was great changing of laws, including the bankruptcy laws in Central and Eastern Europe in the 90s, but we didn't change the judges. And it can be generational change required for folks to understand what the priorities are of the change in law. And so it's terribly important with any change you might pursue that there be great socialization and education of what the objectives of the change are. Are those changes to help rehabilitate companies or to pay creditors? Is it to simply adjudicate litigation? Or is it to find practical solutions so that you can maintain employment, maintain a flow of goods through a company? One of the, I know I'm running out of time, so I just wanted to make sure I touched on a couple of the highlights of Chapter 11. This is just a plug for Chapter 11 as a model. First, the automatic stay is incredibly efficient and buys time. Liquidity buys time, and the stay is a way of preserving cash in the business, not paying it out to creditors, Secondly, that management can stay in place. You want the institutional knowledge of how that business runs, so long as management can be reoriented and understands that it's a duty of care to its creditors, that they're now effectively the owners of the enterprise value, as the shareholders used to be. The access to fresh capital, debtor in possession financing, is probably the single most valuable tool that helps you to catch the falling knife of a business that has run out of money and can't run itself. 363 sales, this was something Ron mentioned in passing, but the ability to get an asset quickly sold and with its assets clean of its liabilities can preserve value. Assets fundamentally find their way from weak hands to stronger hands. And so 363 allows one to quickly execute a sale if that's the best way to preserve value of that enterprise. And the last thing I'd point out is the power of the court. Unlike almost any other court in the United States, and we have many, we have a very complicated legal system. The federal bankruptcy judge has broad powers to take all kinds of issues into their court, including international ones, Chapter 15. But it allows for I have found almost uniquely that federal bankruptcy judges are incredibly practical in how they apply the law to try and help businesses resolve their issues with their creditors, but stay alive through the bankruptcy process and into the future. And so giving the necessary authority, part of this bankruptcy process, and here again, I'm the one non-lawyer on here, but I keep advocating for how to reform your legal system, is to make sure that the judges, that the law gives the authority to take all relevant issues into account so the cases don't get stuck. Like bringing a very sick patient into an operating room, generally you want to be in the operating room for as short a period of time as possible. And you want to make sure you've got all the skills necessary in there while you've got your patient open to make sure you get them put back together again in one piece. If you don't have everything you need in the room and you spend a lot of time waiting for it, the patient will probably die on the table. And so, the stay, control of management through the bankruptcy, debtor in possession financing, the ability to sell quickly, and the ability to solve problems very practically in court are all things I would want to bake into any reform of any legal system in Sri Lanka or anywhere else on earth. I think there's much to be borrowed from both the UK system and the US system. But I encourage you to use this, never waste a good crisis, we say in the crisis management business. Use this opportunity to change your laws so that the maximum number of businesses, and think employers and engines of industry, can be rehabilitated as quickly as possible for the faster economic recovery of the country. We as a firm would love to be involved in that process. That's why I got out of bed so early this morning, is to share these ideas with you. And I really appreciate your time and attention. Look forward to answering some questions. Thanks.
Okay, I'm sure there'll be a lot of questions, but the key takeaway, Peter, that I had is the 3 years: leverage, liquidity, and leadership. And I think, as I agree with you, leadership might be the most important of the three. So let's see what the audience will have in store for you. Now I'm going to move across the seas to our big brother, to Mr. Dibanshu Mukherjee, who's going to talk about the Indian perspective. Over to you.
Thank you so much. At the outset, many thanks to the Bar Association of Sri Lanka for reaching out to us with this opportunity. We hope our contributions will be useful for you. So I have a few slides to share. Just give me a second to just share them for you. I hope you can see my screen.
We can see it. Okay.
So, before I talk about the new law itself, I want to briefly talk about our pre-reform law. And that's because the experience that we had with our old insolvency regime had a huge impact on the design of the new law. And I thought, it will be useful to first talk about how the old law was designed and why it failed, and how did it actually influence the design of the new law. So before the new law, which is essentially the Insolvency and Bankruptcy Code, which is known as IBC in India, came in, we had two different laws for dealing with corporate insolvency. The first one was called the liquidation regime under the Companies Act, which actually has been on our books since 1866 in some shape or form as a law that was originally inherited from the British. And a second reorganization law, which came into force only in 1985. It was known as the Sikh Industrial Companies Act. And that remained on our books till 2016, when the new law was enacted. Now, both these laws were seen as monumental failures, and I'll now talk about why they were failures. So let's first talk about the liquidation piece under the Companies Act. Now, this liquidation system was essentially a collective recovery procedure, as I said, inherited from the British. And it relied on a very subjective test of insolvency for admission. And it was a very complicated test that required detailed production of evidence at the admission stage, as a result of which it took a lot of time for courts to admit petitions relating to insolvency. And even if a case got admitted, and sometime it took years for admission, the courts would eventually not order liquidation on extraneous considerations. Like, they would see that the company is insolvent in balance sheet terms, but if they see that employments, there are lots of employees who might lose their jobs, there might be other implications for the economy, so they would say that no, we can't order liquidation. So it had several implications for the system. Now, it became highly inefficient. It took years for one to get a liquidation order. Another important piece here was the fact that even if a liquidation order was made, the estate was managed by official liquidators, which is not a person, but actually an entire office, which would run the liquidation process. And these people were on the rolls of the government, they got their salaries, but they made the entire procedure highly bureaucratic and again prone to delay. So at one level, you had delays caused by the courts or due to the courts, and then this other layer of delays caused by by the manner in which it was implemented through official liquidators. Now, the government did see that the system was largely defunct, and therefore brought about what was known as a corporate debt restructuring scheme, which was supposed to be a scheme that would allow banks to enter into negotiations with debtors and try to settle the debts outside. But in the absence of a valid threat of liquidation, because the liquidation system was so defunct, there were no incentives for debtors to actually genuinely cooperate with creditors to try and settle their debts outside. And therefore, even the out-of-court system proved to be a huge failure. UK significantly reformed their law in 1986, as the previous speaker also kind of referred to. They brought in the administration system, but India didn't, despite having inherited the law from the UK. It did not keep the law in sync with what was happening post 1986. Now let's look at the other law, the Sikh Industrial Companies Act. Now this law, it applied largely to industrial companies, and this was a function of the nature of the economy in India at that time. We had these large industrial players, some of them owned by the government, a lot of them owned by family-run businesses. And in the 70s and 80s, we had a huge period of insolvency, as a result of which this law was enacted to help them with reorganization. And this law was influenced by the Chapter 11, of the US Bankruptcy Code, because I understand that came into force in 1978, and this is, it's around 85. It was one of the biggest things that was happening globally. But this law also failed terribly. Let's look at some of the specific reasons. Now, the entry or the trigger event which allowed someone to approach the system, to start the process was based on this test of erosion of net worth, which actually happened much later in the life cycle of distress. And therefore, the moment a person became eligible to file for bankruptcy under this law, that person had already kind of reached a stage of, have gone beyond cure, so to speak. So therefore, the trigger event was not designed properly. Secondly, like the US law, it provided for an automatic stay on filing in combination with allowing the debtor to remain in possession. Unfortunately, this was heavily abused by the debtors, because unlike the US, where the management by and large is independent of the owners because of dispersed shareholding. The other speakers may correct me if I'm wrong. In the Indian context, the shareholding is highly concentrated in the hands of family-run businesses, and it became easier for them to use the automatic stay to abuse the process, siphon of assets while the bankruptcy proceedings went on. So although this was kind of something taken from the US, it did not work very well in the Indian context, given the nature of our businesses. So it's something to bear in mind as you design your own process. Now, again, unlike the US, which was kind of code-driven, as the previous speakers mentioned, here the law was kind of governed through a government authority called the BIFR. Again, it was kind of in sync with the nature of the economy, where kind of a hangover of the Victorian colonial past, where the government will tell you how to resolve your insolvency. So that was the approach. And therefore, once a case was filed, everybody was brought together, but ultimately the final decisions on whether to rescue or liquidate, etc., was taken by the government, this government authority. And this entire regime suffered from what was known as a rehabilitation bias, where companies were allowed to remain functioning despite being completely unviable for years, irrespective of whether there was any real business that was there to be rescued. And I can go on and on about what this rehabilitation bias actually meant, but broadly, there was more at play than commercial viability of the business for deciding on whether to rescue or liquidate, and which was a huge problem. Then this regime was very prone to holdouts by trade unions, and other creditors other than bankers, who could actually, who would insist on payment of their dues, all their dues, before allowing for the proceedings to go on, which obviously made it extremely difficult for the process to move forward. And lastly, even if there were any final outcomes that came as a result of this process, they were litigated for years in our constitutional courts. It was easy for anyone to file a writ petition challenging the final order. And unfortunately, those petitions would also get entertained in the constitutional courts. And the end result was that you had no efficient outcomes whatsoever. Now let's talk about the new law. So the new law is kind of designed to address some of the problems that we saw in relation to the old system. So it completely does away with the two old laws, and it kind of harmonizes the entire restructuring piece under one law. There is a separate section dealing with insolvency of individuals also, but we are not getting into that for the purpose of this discussion. I'll just quickly take you through some of the key features of the new law. It's unlike the previous system, market-oriented and deal-based. The government has very little control. The courts also have very little control. The economic logic kind of drives the process. The trigger for entry is a single default. So it's very different from the cumbersome insolvency test under the liquidation regime or the erosion of net worth test under the SICA regime. So it's just a single default of 1 crore rupees. The moratorium is not automatic. A case has to be admitted for the moratorium to be applicable. It's robust and has wide scope, but it's not automatic. Then this piece is actually huge. So what happens to the management during the process? So the management actually gets displaced by an insolvency professional who is an independently regulated professional. And this is a huge thing in the Indian context where lots of companies are family run and operated. Displacement by an external person for an insolvency process is a huge change and a huge shift. And again, this is informed by experience with the old regime, especially the Sikh Industrial Companies Act, where the debtor in possession model did not really work. Now, once this insolvency professional is appointed, he or she collects claims from all the creditors and forms a committee of creditors. The committee of creditors are the key decision-making authority in the entire process, and they take decisions for everything during the process. The plan itself, this is kind of sort of influenced by the US regime, where people can submit plans. Unlike the US, there's no exclusive right for anyone. Everybody can submit their plans. It's an open market process. And then the committee of creditors goes with the plan that considers to be the most appropriate for the business. And the relevant threshold is about 66% by value of the creditors present. And importantly, we have a specific timeline in the code which says that the entire process has to be closed in 180 days, which is extendable by another 90 days. But the idea is the reorganization or the decision to go with a certain plan should be completed within this window. There are some question marks over the implementation of this in practice, but at least the intent is to make sure that everything happens in a time-bound manner. And there is a specialized tribunal, it's called the National Company Law Tribunal, which kind of oversees the process, but its role is very limited in comparison to what the high courts had in liquidation or the BIFR had in reorganization. So it's relevant for the purpose of admission and grant of moratorium in the beginning, and of course also approval of the plan in the end. But other than that, it's largely kind of limited. Then let's talk about some of the unique features of the law, which I don't think any other jurisdiction has. Now, firstly, this committee of creditors that I talked about only comprises financial creditors. These are banks or institutions which give loans on interest. It's only them who comprise the committee of creditors. Operational creditors can send representatives if they meet a certain threshold, but have no say in the process. So it's actually, again, a huge radical thing, something that, I don't know of any other jurisdiction which excludes suppliers and operational creditors in this manner. But again, it's kind of influenced by our experience with the previous system, where a lot of operational creditors kind of held out and did not allow the process to move ahead. So while they're excluded, there are several protections in the code for making sure that they are not oppressed by the financial creditors. But again, this is actually a huge thing, the fact that they're completely excluded. And the second unique thing is the fact that we no longer have direct recourse to liquidation. One has to necessarily go through the reorganization process, and there the committee of creditors will decide whether to rescue and invite a plan or send the company into liquidation. So there is no direct entry into liquidation as we used to have under the previous regime. So again, this is a very unique feature of the law, and it's kind of linked to that time limit I mentioned. So the provision says that if the creditors are unable to come to an agreement within 180 days or 270 days, if there is an extension, the company will automatically go into liquidation. So it's kind of a legal guillotine which will fall, and the company goes into liquidation if the creditors don't act in time. So it kind of forces everyone to come with clean hands and try to resolve as soon as possible. And the third piece is we have this regulator that the law sets up to not only regulate the insolvency professional, who's actually displacing the management and facilitating the whole process, but also regulate some of the processes within the proceedings, like how does the auction run, what are some of the core features that the plan must have, so on and so forth. So essentially, we have this regulator not only looking at professionals, but also keeping a close eye on the process and making rules for that process. And I already mentioned that courts have a limited role. So broadly, that's the regime. And we've, as I said, there are several features which we have kind of borrowed from the US code. The first speaker talked about rescue finance. We also have a provision for interim, we call it interim finance in the Indian context, but here you need the permission of secured creditors for that to happen. So there's this huge conflict as to whether it actually happens in practice or not. But there is no permission of court required. So to that extent, it's different from US, where you need court's permission for getting that super priority. Now, so that's the law broadly. Now, I want to briefly talk about the process of reform, so that if it's of any use. So the committee that that designed this law was set up in August 2014, and it released its first report in February 2015. And I want to emphasize on this because this report, which is first 6 months of the committee's work, was only on understanding the reasons for failure of the old regime. So we didn't get into drafting the law straight away. The first 6 months were spent in understanding what went wrong. So there is this report. This report is publicly available, and it talks about in detail, in depth, about reasons for failure of the old system. Then in the second leg of the committee's work, they designed the law, which eventually came out in November 2015, along with the draft bill. It was tabled in the parliament in December 2015, got referred to a parliamentary committee. And then eventually in May, it was passed by the upper house of the parliament. It got implemented in record time. The regulator, which I just mentioned, was set up in October 2016. And by December 2016, all the regulations were in place and everything was implemented. And we had a first case in Jan 2017. So it took about 2.5 years in all, from the setting up of the committee, conceptualization of the reform, to its implementation. So it was a very exhaustive exercise. The last leg was kind of completed in record time. And we were fortunate to have advised the government throughout from 2014 to its implementation. Lastly, I just want to briefly talk about the impact. Now it's changed the ecosystem radically, and people have said that from a blank slate, this has become a boom town now as far as corporate restructuring are concerned. It has changed the debtor-creditor relationship radically. Now, debtors have become more disciplined, when it comes to taking debt. Creditors have also become more, disciplined about giving debt. And it has changed the relationship dramatically. I mentioned that, in the earlier regime, the debt restructuring piece that the government had introduced, the out-of-court piece, it had failed miserably because there was no threat. But now, because of this new law, in addition to the good outcomes that we are getting in the law, because of the success of this law and the threat of displacement of management, a lot of debtors are coming forward to settle their debts voluntarily. And this is a huge cultural shift, which you will probably not hear about in terms of actual numbers, because we don't even know what these numbers are. But a huge amount of debt is getting settled outside of the system because of this credible threat of displacement, which is now working effectively. The NPA levels, which is essentially the non-performing assets in our banks, have come down significantly from 2016, when this law was first introduced, to now, where the number is around 12 to 15%. In 2016, the number is down to about 5% now of the entire banking industry, which is actually a huge impact in in terms of money. It roughly amounts to thousands of crores. Now, I want to briefly talk about some of the support systems, because Mr. Briggs mentioned the importance of the context and how, when one kind of looks at other jurisdictions and when they adopt them, they should also look at what are the important things in that ecosystem which make them work. So here in India, one radically good thing that has happened is that the government has been deeply interested in this reform, and they have done several things to make sure that it continues to get implemented, because enacting the law is one thing, and also enforcing it properly according to its true intent is a different thing altogether. And the government has kind of done a great job there. So the Ministry of Corporate Affairs, which is the ministry that kind of oversees the entire process, has set up a permanent committee to monitor the implementation of the law. And this committee kind of looks at how the law is being implemented on a yearly basis and comes out with recommendations for reform. So it's just not a one-time thing that you design a law and it's done. So they design a law and then they set up a committee to monitor, to make sure that whenever there are, over a period of time, the law has been amended multiple times in response to the feedback that it has received from the market. So that's another reason why the law is working relatively well. And this regulator, the Insolvency and Bankruptcy Board of India, one of the unique features of the law that I mentioned earlier, they have done a fantastic job in ensuring that they show the system the mirror, tell all the stakeholders about how they have been performing. They collect data from all the insolvency professionals, courts, and report that information, make that public on a quarterly basis. That helps the entire ecosystem understand how well is this law working. So there is data about anybody who wants can have access to the number of cases that are filed, the kind of recoveries creditors are getting, how much are financial creditors getting, how much are operational creditors getting, which industries are doing well, which are not doing well. And this is being reported on a quarterly basis. Again, this is a huge feature in the law, which is kind of helping it in its smooth implementation, because people know that this is what these are the problems and they need to be rectified. Secondly, the Reserve Bank of India, which is a banking regulator, has also done a lot, especially in the beginning when the law came in. Banks were reluctant to use it. It kind of pushed banks, saying that no, you have to go and try and use this new law to see if we get any outcome. So kudos to them too for having supported. Then lastly, the judiciary, our constitutional courts, as I mentioned, for the old regime, they entertained too many writ petitions which challenged final outcomes. That has completely changed under the new regime. So our constitutional courts have been very supportive and have not entertained any writ petitions whatsoever which challenge the final outcomes under this new law. So actually, that's a huge change, and which is and stakeholders, recalcitrant debtors have challenged the law in several cases, saying that it's unconstitutional, etc. But time and again, the constitutional validity of the law has been upheld, especially given this radical change that they're displacing the management. And the courts have understood the fact that if the equity is wiped off, the promoters should have no say, and it's the creditors who must take the decisions. And that's kind of become ingrained in the system, and it's working really well. And it's heartening to see that our constitutional courts have been supporting the law. Now, I'm just briefly talk about some of the challenges going forward. Not everything is great. Pendency is an issue. Like there are several cases that have that remain pending in the system, although it's not as bad as what the system under the old regime was, but we still have a huge number of cases that are stuck. But at least that threat of displacement is still there, as a result of which we have a lot of out-of-court settlements, but pendency is an issue. Exclusion of operational creditors, like from the decision-making process, on the face of it sounds really, really huge, right? Because trade creditors have no say in the process. Absolutely not. So this is a slightly controversial piece, and it's a moving target. Some people say that they're being treated unfairly and therefore they need more. They should get more out of the process. But let's see whether that debate finally ends. Then I'll briefly talk about the kind of other reforms that the government has been thinking about, especially cross-border insolvency. And here I'll only mention that at the time when the law was being designed, it was felt that the cross-border insolvency piece sits on top of a well-functioning domestic piece, and therefore it was not introduced right at the outset. So the thinking was that let the domestic piece be designed first, let it settle down first, and then let's introduce the cross-border regime in India, because it largely operates on the principle of reciprocity. And there is no way people will recognize our system unless it functions well. And now we have reached a stage where Indian proceedings are getting recognized in other jurisdictions without us having adopted the Uncitral model law. And now, therefore, time is ripe for us to adopt it. And the government has already floated a paper and proposed a law. But in terms of sequencing, we thought that it makes much more sense to introduce it after the domestic piece settles down, and I think that's happening now. Yeah, so I hope I didn't overshoot my time by much, but I think that's about it on the Indian regime, and I'm happy to answer any questions as we move along.
Vivanshi, thank you. Some of the key words that I picked up was rehabilitation bias. So you're basically going against the first two speakers in one context, but what I get from you is that with regard to maybe the Indian subcontinent, we might have to think about applying Chapter 11 as it stands, and we might have to adopt, especially when you consider, as you point out, holdouts by trade unions, and also the role of courts, which might sometimes not be advisable in the Indian subcontinent. So thank you so much. Let's move on to the Asian continent per se, and let's listen into Mr. Nicholas Muller on the Asian perspective of insolvency. Over to you.
Thanks very much, and thanks for the Bar Association for inviting me today. I hope you can all hear me.
Yes,
Okay,
we can hear
great,
you.
thanks. Thank you, yeah. So just to say a little bit about myself and ADB. So I'm in the legal team in ADB, and I do mostly private sector work, helping mostly new money deals get done. But we also have a few recovery cases to work out as well. But I'm here today more to talk about what I do in the team that we call the Law and Policy Reform team, and in particular the insolvency work we've done around the region. So hopefully I can get through that. I'll talk a little bit about the experience we've had in insolvency reform in the region, and people hopefully can take something out of that. But briefly, in case anyone is less familiar, so Asian Development Bank is a regional multilateral development bank, much like European Development Bank or the African Development Bank or the Inter-American Development Bank. We are one bank that has both, if you like, the sovereign and non-sovereign sides within it. So I'm sitting in, if you like, if people are familiar with the IFC part of the bank, that's where I sit. And most of our work is in lending. So in the past 55 years as the bank, most of the work of the bank has been in lending on the sovereign side mostly, and providing technical assistance, grants, making equity investments to promote social and economic development. But that is changing slightly now. We have more of a focus on becoming also a knowledge-based organization, and this is where the Law and Policy Reform team comes into fray. So we have a separate team within the legal department that just does law and policy reform. I'm part of that team, and most of the work we do is legal and regulatory reform, but we also do capacity development and just general knowledge resource work where requested. And we do a wide range of things, all from digital economy to the environment to gender related and specific things like combating money laundering, financing of terrorism. And I'm in the team that does private sector development. And I'm running a particular technical assistance program, which is again widely titled. It's in relation to creating a better legal environment for the private sector. So things that people do in this technical assistance program include PPP reform and arbitration reform. But the only thing I do is insolvency law reform. So in the last 5 years, I would say, we have worked in a lot of countries, most notably Myanmar. We were able to get new law there. And I'll say a little bit about that in the future. And we're currently working in countries as diverse as Armenia and Bhutan. And a number of other countries we are in discussions with, including Indonesia, where I was speaking on Monday. So why are we interested in insolvency law reform? Probably this is going to be pretty obvious to you all, but I'll say it anyway. Every economy needs a way of dealing with people and companies that are in financial difficulty. There is a public interest in providing an orderly approach to working these things out, to enforcement, to respecting the different players that have been discussed by the other speakers. There's the creditors, obviously, and their security, and then there's the employees, and there's also the community. So there's that wide range of public interests. For me, I'm Australian, by the way, so I come from a penal colony. This is where people that didn't pay their debt used to be sent. So if you're looking at a spectrum of how to do an insolvency law, that was one way. That's I can hopefully say now a way that we are doing away with, although some of the countries I've mentioned still send people that don't pay their debt to jail. So that's one little thing that we're trying to eradicate. But obviously there's more to what we do than that. Let me continue. Okay, so what generally is our approach in insolvency law reform? So we don't, as a multilateral organization, obviously we cannot recommend one particular member country's laws. So we have a principle-based approach rather than a, copy and paste or, favoring a particular country's approach, although I think a lot of the principles will be familiar from what we've already heard about Chapter 11 and Chapter 15. So these are things like trying to maximize the value of a debtor's assets, striking a balance between rescue and liquidation. For on the creditor side, at least for equally situated creditors, treating them equally, trying to get to timely, efficient, important resolutions, preventing abuses of the system. So that can mean, as we've heard from other speakers, allowing the management to stay in the business and to continue managing the business. I think a lot of laws will have protections there in place. So there was an expression earlier, but the expression I hear in Asia, parts of Asia anyway, is to avoid, obviously you'll have fraudulent protections, and the expression we hear is to prevent the rats being left in the rice. That's the expression currently in vogue in these discussions. Obviously, we're also, as the world is fully cross-border now and everything's interlocked. We are very much interested in cross-border insolvencies and facilitating that. But generally about coming out with something that is a process that can be applied in a predictable manner. People have mentioned priorities as well, and obviously employees are there as a priority and a principle, to respect employees' rights. The other one we see at the top of the list in some countries is the tax man. We will leave that to a particular government to decide whether their tax man should be the first person paid in any of these workouts or insolvencies. So from what I've said, you can probably guess that the objectives we see are basically either rescue, so where that's possible, obviously that should be promoted, where value can be preserved, the employees can keep their jobs. Creditors, get to keep their customer. So, that's all good and is to be promoted. Obviously, there are some cases where the enterprise is just not going to be workable going forward, and then you'd want a orderly liquidation process where those secured creditors we've been talking about would have their debt respected, but also unsecured creditors would also be treated equally and have some protection. So because we deal with countries with lots of different legal backgrounds, I think Peter's alluded to working all over the world basically, and different systems with different backgrounds. We do see a bit of a difference between common law and civil law jurisdictions in the way they approach insolvency law. And that's definitely a factor in designing your new law. The age of the law, also a relevant factor. So we've seen reference to some quite archaic laws so far in presentations. I think the the older it is, the more likely it's going to be useful for a modern economy to function properly. Then we'll also look, when we're looking at a law first time, does it include any corporate rescue or rehabilitation process? As has also been discussed, some of the older laws did not have those, or especially did not have them at all, or did not really promote them. They were all more about liquidation and winding up companies as quickly as possible. This is a trend I'll get to more, but is there any particular protection for MSCs, small medium enterprises? So we see in a lot of countries around the world, but especially the countries that we work with in Asia, that small medium enterprises are a huge part of the economy, like 70, 80%, 90% of the economy. So the more MSMEs you see, the more likely it is that an expensive, timely process in court is not going to work and is not going to achieve a very good outcome for the small medium enterprises. Then other cultural legal background things that we look at are what role does the judiciary play? Is the country you're looking at very pro? Is everything going to happen in court? Does everything require a judge to make a decision? Is every single step through the way going to involve the court, or is there more that happens out of court? And a related point then is the role of the insolvency practitioner. So do you have a whole group of organizations that are formed of lawyers, accountants usually, that go into bat, that are experts in the field of insolvency and can properly advise companies and persons that are in distress? Okay. Very briefly on Myanmar and what we achieved there. So we advised on the law that became the Myanmar Insolvency Law 2020, came into effect in 2020, replacing a 1909 Insolvency Act of Yangon and a 1920 Myanmar Insolvency Act. Again, these were based on the old British laws that others have mentioned as well. So they were very much along the lines that people have already described. So, for example, it did not have much at all in the way of dealing with rescue and rehabilitation of enterprises. It was split out across different laws. So you would have the company's law dealing with liquidation. Personal bankruptcy was dealt with separately in separate legislation. And of course, there was no mention at all of cross-border insolvency. So the law that we produced there incorporated all these things into the one place. It repealed some things in the old laws and just completely did away with some of the old law. And of course, when you're moving from basically ground zero, where there was basically no law, and there were no practitioners, and there hadn't been a practice at all of any rescue or rehabilitation, the only thing that practitioners did for roughly 40, 50 years was to liquidate companies. That is going to involve a lot of new capacity training and development. So we spent years with the Supreme Court training up judges. We also spent a lot of time helping the creation of the Insolvency Practitioners Association, its regulation, and then their training basically on basic commercial law above, even beyond insolvency law matters. The other feature of the law was that it did have a separate chapter to deal with small, medium enterprises. So there were quicker, cheaper processes with different voting thresholds, if you like, for the rehabilitation or the liquidation of small, medium enterprises. So that was Myanmar. For now, by contrast, we're doing Armenia, which is completely civil law system with its heritage in the old Soviet laws. Another challenge, but yeah, a good one to have. And then another one to contrast is Bhutan, which is a landlocked, small, very small economy. And they had they've got very old laws as well. Their laws are basically anticipating that they would have a lot of large enterprises, whereas obviously mostly there are a lot of small traders and small enterprises. So the exercise there is really simplifying the laws, simplifying the processes, making it as much out of court as possible to help keep the costs down and to keep it quick, to help all of the capital in the economy kept moving around. So apart from those roles, I could talk briefly about what we saw perhaps during the pandemic and then coming out of the pandemic, because there were a lot of interesting special measures adopted throughout all over Asia during the pandemic. The biggest and most obvious one was that creditors had their rights to commence proceedings moratoria suspended in a lot of countries across Asia for a period. I think this did include India, but also Singapore, Philippines, China, Thailand, Indonesia, etc. In some countries, there was a relaxation on the liability for wrongful trading, so that entrepreneurs were encouraged to stay in the business, keep it floating, keep going, without fear of fear of being held liable for any kind of wrongful trading while the company was insolvent. Contracts were able to be terminated outside insolvency proceedings in Singapore and Malaysia as well. For financial institutions, and I guess this was across the world, but there was a big relaxation on loss provisioning and capital requirements. And more generally, there was a lot more of a focus on allowing and promoting electronic communications, including between courts and out-of-court workouts more generally. So some of the old ways that we'd seen out-of-court workouts being done in the Asian financial crisis at the end of last century came back, made a little bit of a comeback during this period. And now, as to what we're seeing coming out and recovering, some of these things have gone away. So generally the suspension of creditors' rights have been disappeared, but query whether that might be appropriate for some countries more lingering with more debt. There are more reforms around Asia focused on rehabilitation reorganization proceedings for viable businesses, which is great to see. More and more countries are adopting specific small medium enterprise insolvency programs. Singapore is leading there. They had a temporary one, and that temporary one they are continuing to this day. There is still some allowance for realignment of contracts that were impacted by the pandemic, so that does continue a little bit as well. And by way of final words, in relation to trends and what we see, the first one, I guess, I'm repeating myself here, but small medium enterprise specific laws. So it's been a focus of the World Bank and Uncitral. They have their own publications on, I think, even model small medium enterprise laws, but the basic thrust of it is that you have quick, simple, cheap proceedings to allow all these smaller businesses to survive an insolvency and to get out without losing too much money or time in the process. So I talked about, yes, we did the Myanmar one, but now Singapore, I think also in India. I also saw Laos, even Laos, whose whole insolvency law is only 35 pages, has a separate chapter on small medium enterprises for more efficient notice periods and different voting requirements. Second trend, I guess, is more out of court or hybrid procedures. So an encouragement of, for example, mediation. So some advantages there might be the more flexibility if you're dealing with rigid legal systems, perhaps some flexibility, the ability to just talk face to face without lawyers, judges around in a less intimidating environment. confidentiality, of course. If you're just having a discussion in a room, that can be kept confidential. And importantly, still for some Asian countries, I think there's still a bit of a stigma attached to insolvency. So if you can mediate behind closed doors, some issues you're having with your finances, that can help reduce the stigma, the whole public side of it, and might encourage you to, generally talk to your debtors or creditors, depending on what side of the fence you're on. And finally, again, something I've already talked about, but cross-border insolvency. So we've seen an adoption more of the Uncitral model law on cross-border insolvency. I think we just heard that India is still considering it, but is looking at it closely. We've also seen in the last few years, Singapore, Korea, Japan already added to the existing list of, I think there were 45 last time I looked, but there must be closer to 50 now. Some countries are still not taking that huge leap and doing that, but are adopting kind of interim measures. So we've seen China and Hong Kong, Singapore and Malaysia, they will have sort of bilateral cross-border arrangements in place. So in Hong Kong and China, it's between Hong Kong and certain pilot cities where there's some kind of mutual recognition and assistance in place for reorganizations and liquidations. For Singapore and Malaysia, it's more about court protocols. So it's much easier now for courts to talk to each other, to have open communication and to cooperate. That is all I have for the moment. I'm happy to answer queries and talk more about what we've been doing in the region, and look forward to further discussions today. Oh, got one hand up from our friend Manjuka.
Manjuka, do you want to pose a question right now or maybe later?
What I'll do is when my closing remarks, I'll put the question. I think that's what I want to do. I have a small little bit questions.
Then thank you, Nicholas, for pointing out the issue about small and medium enterprises, including giving us examples about Myanmar and across the Asian states. Now, I think we say the best for last, since real reason for BASL to bring in all these experts is to identify probable areas of improvement. And I think there's nobody else in Mr. Chanaka, this is our President's Council, who has a wide gamut of experience, who have seen many times in the commercial high courts, and who has so much of experience. I'm pretty certain all of us have been waiting to listen to his perspective as well on the Sri Lankan law and maybe the lacunas and the way forward. Over to you, sir.
Thank you very much, Shahan. And it was very interesting to listen to everybody with regard to their presentations, particularly with regard to the Chapter 11 processes and what flows from that. Now, what is the essential difference between the Chapter 11 processes and liquidation? I think the difference is very simply in liquidation, you're trying to wind up a company, you're trying to end a company, and you're working towards closure of business. Whereas in Chapter 11, you're trying to restructure the company, you're trying to reorganize the company to see whether the company can carry on business. Now, why is it important for any party to do that? It is important for one very simple reason. When you're trying to wind down a company, very often there is not much value going to be gained by anybody. The assets are going to be sold at essentially what is called forced sale value. And there are lots of people who are going to suffer. In other words, all the stakeholders of the company, that is the workers in the company, the creditors of the company, the debtors to the company will gain, of course, perhaps if they don't have to pay their debts. But then the equity holders will also take a huge hit. Now, this is not the only thing that happens in winding up. In winding ups, very often, there is what is called a knock-on effect. And that knock-on effect goes even to the creditors. because it affects very often the creditors' balance sheets. If they're exposed to one debtor very much, then their balance sheet may get a big hit. Now, not only that, it is going to also affect the workers. Particularly in a context where there is very little employment opportunities available, if there are lots of workers and all that, that's going to have a tremendous impact on the economy. So these are aspects that have to be looked at in the context of liquidation. And that is why reorganization is looked at. One looks at reorganization because it is always better for a company to be running. When a company is running, the company will be able to earn and the company will be able to repay the debt. The assets of the company will probably fetch a better value, and it is probably going to be put to better use. So this is really the rationale behind looking at reorganization as opposed to winding up or liquidation. Now, of course, if you look at Chapter 11, in the Bankruptcy Act, in addition to Chapter 11, you also have Chapter 7, I believe, which deals with liquidation. So if by any chance the restructuring does not work, one moves from Chapter 11 to Chapter 7. Now, we saw the same process in India. So that is giving the chance to see whether the particular corporate entity could be restructured before one goes into the winding up setup. Now, if you look at certain companies who have come from restructuring or Chapter 11 processes, in the US, you have companies like GM, General Motors, Texaco, Marvel, I believe. And in the airline industry, I believe Delta went through a winding up process. And they are now operating. They are operating quite well. Delta, I believe, may have been taken over, or there was a taking over or something. Can't remember the details of it very much. But these are entities which went through restructuring processes and came through success. Now, that is the reason why we need to see, rather than going up the winding up route, whether you can actually restructure these companies. Now, if you achieve a target of about 25 or 30% of companies actually coming through restructuring rather than being bound up, that also is going to be a positive factor. You are at least saving 25-30%. If your percentage can be higher than that, that is so much the better. Now, in this context, what are the provisions that are provided in our company? If you look at the setup, what is most popular in relation to insolvency proceedings is the liquidation process. And if you look at our Companies Act, there are lots of provisions relating to liquidation process. Even in our old Companies Act, it was like that. And if you look at the Companies Act liquidation processes, there are fundamentally three processes or two processes which are available. You have whichever way you look at it. You have voluntary liquidation, you have liquidation by court. And voluntary liquidation also could be subject to supervision of court. So depending on the way you look at it, it can be 2 or 3 separate processes. However, those are really not the only provisions that are there in our Companies Act. In our Companies Act of 2007, there are certain provisions which are there, which have been introduced for the purpose of doing some kind of restructuring, if possible. Unfortunately, in our country, we don't use these provisions very much. Perhaps we should be looking at them also without running towards liquidation almost all the time. Now, what are these provisions that I'm talking about? One is Part 9 of the Companies Act. It starts with Section 247. It deals with compromisers. Then you have Part 13 of the Companies Act, which deals, I believe, with starts from Section 401, and it deals with administration. And there is Part 10, which deals with approval by court of compromises, arrangements, and amalgamation. And that deals with, or that starts from Section 255. Now, I will try and look at each of these provisions, not in too much of detail because of the time situation, but very briefly to explain to you what these processes are. Now, compromise is described as a process where there is cancellation of all or part of a debt, varying of rights of creditors or the terms of debt, or relating to the company's, altering the company's articles in a manner which affects the ability of the company to pay their debt. Now, how can this compromise be done? Actually, the compromise can be done outside of court. It's essentially a process which is supposed to be outside of court. It can be started, or a proposal for compromise can be started by the board of a company, a receiver appointed to the company, an administrator of a company, a liquidator of a company, a creditor, or a shareholder of a company, so long as they obtain leave of court. Now, a receiver, administrator, liquidator generally comes in when the company is really in trouble and has gone through that process. But the company, the board of the company itself can act in a different manner, or can act before that. On the other hand, shareholders or creditors can also act by going and obtaining the leave of court. Now, in that context, the effect of compromise is, once the compromise is approved by the creditors or a class of the creditors to whom it applies, it is binding on the company and all the creditors, or that part of the class of creditors to whom proposals notice or notice of the proposal was given to. And there are specific provisions as to how the approval process has to take place. Now, what is very interesting in relation to this is, once a compromise is reached, so before I go further, what does a compromise mean? So essentially, a compromise in this context means getting together with your creditors and bringing the other stakeholders and agreeing on a manner in which you're going to deal with your debt. It's as simple as that. One does not have to go to court to do that. But that is probably going to be a bit of a difficult exercise, because every bank or every creditor or every class of creditors will want their pound of flesh and will look at maximizing their position. Now, since this is being dealt with outside of court, it is going to be a bit of a difficult process. Now, in relation to this, what are the powers that are given to court? Court has certain powers on the application of a party. So, either a person who is presenting the proposal for compromise or the company can go to court. They can, of course, get directions with regard to how it is going to be dealt with and so on. And in addition to that, they can get an order of essentially like a moratorium for a very short period. Now, the short period essentially is for the proposal to be put to the parties, not for anything more than that. So therefore, one does not give the company sufficient breathing space in order to actually see whether this works or not. So in other words, when the proposal is made and the proposal is and the notice of the proposal is given, then until the proposal is put to a vote, there can be a bit of a moratorium which is given. Now, unfortunately, the problem with this is that the actual making of the proposal has to be made in a context where these positions are not there. It's only once you develop the proposal that the moratorium comes into being. So therefore, nobody has really an incentive to sit together and put together a proposal. Now, on the other hand, there is also the provisions relating to what is called appointment of an administrator. That's in part 13. Now, who appoints an administrator? Administrator can essentially be appointed by the board of the company. When can they do that? They can do that essentially when they think that the company is likely to become unable to pay their debts. So in other words, we know that in certain circumstances, the board has the obligation of looking at the ability of the company to pay debts when it is running in certain situations. And in those situations, appointing an administrator is one of the options that is available to the company. And secondly, an administrator can also be appointed if the survival of the company or any part of the company can be run as a viable concern in a certain situation when they see, obviously, you're looking at them in difficult circumstances. When you look at this, you will see that. Secondly, for the purpose of developing a compromise. So the compromise can actually come from the appointment of an administrator or following the appointment of an administrator. Thirdly, when it is more advantageous for the realization of assets to take place under an administrator rather than under a winding up. Now, although these provisions are there, one must still keep in mind that there are certain provisions which are there in the liquidation provisions, where certain types of transactions can be challenged or set aside because it happens very close to the winding up of a company. So in those circumstances, that third situation I was talking about, or probably even the first and the second situations that I was talking about, may not become very feasible because your title might be questionable after some acquisitions and so on. Now, these are tricky issues that arise in relation to appointment of administrators or a compromise. Now, what's the effect of appointment of a compromise? Appointment of an administrator. Once you appoint an administrator, there is a bit of a moratorium which is given until the administrator position or the appointment is put to the creditors. Now, once it is put to the creditors, if the appointment of the administrator is approved, then there are certain provisions which follow. If the appointment of the administrator is not approved, then the moratorium ends. And of course, a different course of action will take place. Now, what happens when you appoint the administrator and the administrator's appointment is confirmed? Once that happens, no resolution can be passed for the winding up of the company. You can't appoint receivers. You can't take steps to enforce any rights against the company or security against the company or repossess any assets of the company. And also, no proceedings and no execution can issue against the company so long as the administrator's appointment continues, other than with leave of court. So therefore, once the appointment of the administrator is confirmed by the creditors, the administrator is given room to function in that capacity. Now, however, what is significant is that although no resolution can be presented for winding up the company, a creditor can go to court and file for liquidation of the company in court. So therefore, although you have given provision or given space to the liquidator to work in one aspect, in the other provisions, that freedom is taken away. So that is an issue in relation to administrators. Now, an administrator has to come up with his proposal within 2 months of his appointment or an extended period thereupon, which is not specifically stated as to how long. But in these contexts, 2 months is a very short time for any party to come up with a restructuring proposal for the company. So therefore, the practical aspects of this, I'm not quite sure how valuable it is going to be. Now, the other aspect is essentially the approval of arrangements, amalgamations, and compromises by court. So once these, either a compromise or an arrangement or a administrator comes up with a proposal or a compromise, one could take it to court for approval and to obtain some kind of orders. what are those orders that can be obtained? According to Section 256 of the Companies Act, the court could make an order on the application of the company or the administrator or by a shareholder or a creditor with the leave of court that the arrangement amalgamation of company shall be binding on the company and other types of persons that the court may specify. In other words, one could go to court and get an order that it is binding on certain parties. That is, having arrived at that, if they dispute that, or if there is a section which is not actually functioning in relation to that, then in such a case, one could get an order from court that it is binding on the parties. Now, there are certain additional orders also that court can make. Court can make ordering the transfer of mobile or immobile property, to issue shares, securities, or policies of some nature, continue or discontinue legal proceedings, for the liquidation or stalling of liquidation, and also for provision to be made for those people who did not support the amalgamation or the compromise. So those are the additional aspects that can be looked after if an application is going to be made for support of amalgamation or support of compromise or an administrator's proposal. Now, in this context, if one looks at what the court does in relation to compromises or in relation to an administrator's proceedings, one really finds that the court actually does not do a supervisory role, but rather a supportive role. It does not happen in court, but if you require, you can go to court and obtain certain orders from. And in the context of restructuring or rehabilitation, one has to consider carefully whether that is the approach that we should be taking. So in that context, when we look at Chapter 11, and very interestingly, the process in India, I noticed some factors. One, the restructuring process itself is statutorily recognized. The process itself is statutorily recognized. Now, what I heard from Debanshu is that you can't go to winding up if you don't go to the restructuring process, which I think is a very positive aspect. Now, secondly, detailed and specific provisions are made as to how the restructuring is going to be handled. In our setup, what we have is a very loose set of provisions, which allows parties to come up with their proposals, but with little to make it happen. If everybody has a will, it might work, but very often it is difficult to find all of the people having that will. Thirdly, you find that there is supervision of the process, essentially supervision by court or supervision by an agency. And in our provisions, we don't see that aspect. The fourth thing that I noticed is essentially that there are strict timelines, about 18 months in both setups, which may be extendable by court. Now, that gives enough time for people to come up with a reasonable proposal following negotiations and discussions with relevant parties. Now, but that, of course, is not too long a time to prejudice the parties very bad. Now, in this context, what is also very significant is the fact that the company is allowed to operate. The company is even in a position where they could borrow money for day-to-day operations if there are possibilities of raising that. When you go into a liquidation process, once the liquidation orders are made, those provisions do not work, or those abilities are no longer there because you are in a winding down process. So it is in that context that the debtor is in possession. Now, it is also very interesting to see the position in India, where rather than the debtor being in possession, insolvency professionals come in. And I can certainly understand the logic, because in India, large companies are family controlled. I think the situation is very similar here. Most of our business enterprises are family controlled or held by a small number of people. And the question is, in those circumstances, if the debtor is in control, would the debtor actually be working for the benefit of all the creditors and the other stakeholders, or whether they would be working for only the interest of certain parties? Now, these are aspects that we probably have to look at in relation to these situations. Right? So, it is in this context that we need to approach the position in relation to the restructuring of companies in our country. And unfortunately, in our country at the moment, we are not paying enough attention to it. And very often, we find that if a company is in financial trouble, it is very difficult for that company to come through it because these processes are not available. Now, if you have a situation similar to the Chapter 11 process, one goes to court and makes an application. When that application is made, the moratorium process is automatic. In India, it is not automatic. Rather, the court has to make an order. But the court will look at the situation in making that order, and in the context of a restructuring, if there is possibility, obviously the court will make those orders. That allows the process to go through. Right? So the salutary nature of that has to be looked at. Now, in that context, I think we must also look at the position of our judiciary, or rather not really the judiciary, but the way in which our court structure works and what really happens. We know that when one goes to court, our court processes generally take a fairly long time. Even liquidation applications take a fairly long time to be dealt with. Although the liquidation rules contemplate very quick action when a liquidation application is made. So in that context, we need to look at the restructuring processes, if that is going to be there, and make necessary provisions in relation to that to ensure quick resolution of the liquidation, of the restructuring processes, rather than those being dragged on. So we need to have strict timelines in relation to what has to happen. And in that context, again, I see the Indian experience of you have so much of time, either agree or we go into liquidation. Is a very novel approach, particularly in countries like ours. Right? So that's a summary of our law in the context of what we looked at. And I think I've left sufficient food for thought for all of us to think about. Thank you very much.
Hello, just that I think we are running out of time, and I thought I'll take over proceedings and thank everybody. The idea behind it was creating a resource, because when the government said that they are going to create Chapter 11, every one of us, all of us just looked at each other and what is Chapter 11? And fortunately, I know Ron a bit before for a long time, he helped me out a little bit before. And then I met Peter. So it was an amalgamation of people. Then I reached out to Devanshu, and then Nick. Nick, are you there? Hello? No, Nick is gone.
I'm here, sorry.
Yeah,
I
sorry.
was on mute,
So Nick
sorry.
is also going to work, I think, on Sri Lanka. We are on heady times, and the best of times, the worst of times, it's say. But it's a lot of reform, and everybody here, now we have resource material. Officials want to look at, they have something to listen to. There are some slides. And I thank you for all of you all to put in this effort together. I'm sure you all are going to meet once more in Sri Lanka. I will guarantee you that all of you all are going to come to Sri Lanka sometime. That I'm quite sure. I will sure. And when I know Peter is coming next month, so we are going to get Peter. And then I can invite Chanak, Mr. Silva to my house for some drinks. And Ron, we will get you around. Don't worry, I'll plot your way to get you down here. There are plenty of creditors around, Ron, for you. The Chinese have 2 sets of creditors. You can get one of them. So we have plenty of work. So it's an exciting time. And I thank everybody for taking their time. It's early morning in America. And thank you very, very much. And hope I'm seeing you soon. And so, Nick, I'm expecting some action from your part.
Thanks very much. Looking forward to seeing as many of you as possible in Sri Lanka, and being able to do whatever we can, to help out.
Yeah, the government has asked for the checkbook. Open the checkbook, so.
Thank you very much.
Thank you very much. Bye.
Thanks. Bye.
Thank you. See you soon.
See you soon. Yeah. See you, Peter, soon. Bye.